Good evening, everyone.
Good evening.
I'd like to thank the church for giving me the opportunity to share my blessings that God has bestowed upon me. And in that regard, I am going to share with you a presentation in relation to planning your estate. The presentation is done in the context of sustaining the family through challenging times. Just a second. It is done in that regard. Is everyone seeing the screen?
Yep. Yes, we are, Charmaine.
Okay, thanks. Right, my presentation is in relation to, or done in the context of sustaining family through challenging time. And as you see here, it is at this time, I think, we need to pause and have a reality check so that we can know where we go from here. So Proverbs 13:22 says, a good person leaves an inheritance for their children's children, but a sinner's wealth is stored up for the righteous. What is estate planning? Having an estate plan is not about how wealthy you are. It is about the stewardship and your legacy. Because a lot of times person will say, I can't make a will because I don't have anything to will. But you would be surprised what you have, and you don't even realize that it is there. So some of the benefits of estate planning. With proper estate planning, you can choose how your assets will be distributed after your death. For example, who will get that special keepsake that you love so much? Your estate will be distributed in an orderly and efficient way and minimize the payment of estate duties and taxes. And that I will speak to in a little bit more details as we go further along. What can I do? You can write a will to ensure that your loved ones are looked after and control where your hard-earned assets go. And this would take effect after death. You can prepare a power of attorney, which is appointing an attorney to make decisions on your behalf, should you be no longer be able to. For example, health afterlife care support. So for example, you are an elderly person and you realize that in terms of your capacity, it is reducing. You can appoint an attorney. And when I say an attorney, you can appoint a child, a friend, so a relative. You appoint them as your attorney to conduct your affairs while you are still alive. You can also give living gifts. That is, you can transfer your assets before you die. So whosoever you wish to transfer your assets to, you can do that before you die. You don't necessarily have to make the will to transfer. You can choose to do that while you're alive. What can I do? You can purchase a life insurance. This is in the context of your estate planning. You can purchase a life insurance which after death, it is able to create or provide some level of financial support for your family in that regard. You, in terms of your funeral planning, you ensure that your wishes are fulfilled and protect your loved ones from uncertainty and unexpected costs. I give you an example. I have always said to my children, I do not wish to be cremated. I do not want to remain on the ice for too long because I am afraid of the cold. So things like those, I know sometimes it might sound morbid, but it is good while you are alive and of sound mind that persons, your survivors can know exactly what is it you would want. You can also create a trust which can operate during your lifetime that can be used to control your assets, protect your legacy, and look after your loved ones. So a trust can operate while you're alive as well as after death. What's the reason for your delay? Some of us, we say we're too busy, it's too complicated, too expensive. Our focus today, however, will be making a will. It is believed that the most important element of estate planning is having a valid will. There's this saying from Dorothy Sayers, who wrote the book Strong Poison. There is something about wills which brings out the worst side of human nature. People who are under ordinary circumstances are perfectly upright and amiable. They go as curly as corkscrews and foam at the mouth whenever they hear the words, I devise and bequeath. And we know that very often, I'm sure most of us have had the experience where we hear of a loved one has deceased, and it is after death that family and friends fall apart. There becomes family dispute, which sometimes lead to even death. What is a will? A will is a legal expression or declaration, usually in writing, signed by the maker and at least 2 witnesses. It indicates your intention for disposing of your property upon death. Why do I need a will? You choose to manage who will manage your estate. You choose who will be the guardian of your minor children. You arrange for the orderly transfer of your assets to your beneficiaries. So when we have a will and a valid will, then this is us putting ourselves in a position to speak from the grave, so that we make our choices and we know that whatever it is that we had desired in our lifetime will be fulfilled after death. Why do I need a will? I'm married. Without a will, your spouse or your partner may not automatically inherit all your estate. I have children from a previous relationship. If you are now married, children from a previous relationship may inherit nothing. And we know the issue of the blended family, and we saw earlier this year the result of what happens when there is death, and we don't know the full story, but there's death and there's issue about what remains in the estate and who should get what. You need a will, you're a property owner. you should specify who you wish to inherit or live in your property after you have passed, and consider protecting your share against possible care costs. You also need a will because you don't want the government of Jamaica to decide who inherits your estate. And we know that, or I shouldn't say we know, just to say that in the event you die without a will and there are minor children involved, then in comes the Administrator General's Department, who now steps in to manage the affairs on behalf of these minor children. And therefore, it is at their directions that things will happen. Further, in addition to them dictating how your estate is disposed of, you are also attracting, or your beneficiaries are now subject to paying a cost, which is 6% of the value of your estate to the government to manage your estate. You make a will, it is the only way to put you in control. It allows you to name your beneficiaries and to specify what you want them to inherit. You may want to add your new grandchild to your will so they inherit something directly from you. So the minute you had a will or you didn't have a will, and you say, because we know how we are, the older persons, when there comes a grandchild in the mix, and we said, okay, I now need to make some provisions for my grandchild. You can easily add or redo your will to make your grandchild a beneficiary of your estate, and the grandchild is now in a position later on in life to say, my grandma or my grandpa died and left this for me. Do the right thing. When you die, you will have no say in how your property is distributed. It gives you peace of mind that your wishes will be respected. If you have a valid will, you will have the power to speak from the grave. I know sometimes a lot of us will say, you know, I'm not making any will because as soon as I make my will, somebody going to kill me, or or I am going to die. And we hold on to that fear, and to our own detriment, we don't make the will, and therefore you have given up your right to speak from the grave. Who can make a will? The law requires that persons have the mental capacity to make a will. This means that the person must be over the age of 18 years, be of sound mind, and must make the will from fraud, force, or duress. So the person making a will, you must have the capacity. You must not be under any duress or force. Somebody not saying you must do this, or they write what they want and tell you to sign. And ultimately, more often than not, it results in you not getting your desired wish in terms of who you want to benefit from your estate. What are the requirements for making a will? Can be handwritten. Some persons might still have a typewriter. You can type it. You can do a computer-generated will, or you can simply purchase a will form in a bookstore. There are, however, certain conditions that must apply, and I will update you as we go further in the presentation. The requirements, it must be signed by the maker. So signing a will by the maker signing a will, if the maker is not in a position to actually write a signature, then the law allows for the person to mark an X. It will require some attestation, but the excuse that I cannot read and write, I cannot sign my name, is not an adequate one not to make a will. The condition, though, which is critical, or one of the conditions which is critical, is that it must be done. It must be signed, rather, so you can write up your will, or in terms of who you want to provide for, but in terms of the witnessing of the will, it must be done in the presence of the two witnesses. All the parties must be in the room, and I notice I said court, so wherever it is you're doing this witnessing of the will, all the parties must be present at the same time. It is good to express it in clear, plain language. You don't need to go online or wherever to research and look for some legal jargons and in order to prepare your will. Clear, simple language is sufficient. If it is witnessed by a beneficiary, it may be seen as a conflict. Now, previously, up to some years ago, if a beneficiary witnessed a will, then that gift to the beneficiary would fail. The beneficiary would not be able to receive that benefit. However, the law has changed, and the beneficiary may be a witness to the will. However, there may be instances when a will is being probated in the courts. The court may ask that witness to provide an affidavit attesting to the validity of the will. So if the court is not satisfied based on what is presented before it, the court may ask for an affidavit to be done speaking to the validity of the will. Beneficiaries. So when you're naming your beneficiaries in your will, use the full name of the person. For example, Anne-Marie Jones versus my dear friend Anne, Miss Anne. Because when we say my dear friend Miss Anne, we are not specific. We do not know who this Miss Anne is. And therefore, it is likely that this gift will fail. You may use an alias to support the full name of the beneficiary. So you said Anne-Marie Jones, otherwise known as Miss Little. You can even go further to, if it is that you have an address for Anne-Marie Jones, aka Miss Little, you can include that. It is not detrimental that if in the will you said of 10 Chancery Street, Kingston 19, and Miss Jones no longer lives at this address, that there will be an issue, because we understand that persons will move from place to place. There will be an instance though, if it is you say Anne-Marie Jones, and at the time of the probating of the will, now Anne-Marie Jones is married, then, and she is now known as Anne-Marie Clark, then what would be required is proof, for example, a marriage certificate, so that it can be established that Anne-Marie Jones is one and the same person as Anne-Marie Clark. What is also important is the spelling of the name of the person. You have Joyce Mary Brown versus Joy Mary Brown. And this is seen as two completely different persons. So care must be taken in terms of when you're naming your beneficiaries, getting the correct spelling right, and to be as specific as possible when it comes to that beneficiary that you're naming. If a beneficiary dies before the testator, if no amendment or change is made to the will, the gift will fall in the residuary clause. And I will discuss later on what the residuary clause is. But just bear in mind this point that if a beneficiary dies before the testator and no amendment is made or change to the will, the gift will fall to the residuary clause. What can I will? What is more important? You cannot will what you do not own. So, for example, property jointly held as joint tenants, for example, a bank account or a house cannot be willed as the right of survivorship applies. And let me pause here, because very often persons, spouse, they would, or even siblings, purchase a property or have a bank account and the property is purchased. Let me be specific. Let me use the house. A house is purchased as joint tenant, but in a discussion with persons, they are talking about my share. When you purchase a house as joint tenants, there is no share. So if it is that you acquire the property and it is as a joint tenant, as joint tenants, then in the event one person dies, then it is automatic that the survivor will benefit from the entire property. So it makes no sense if you have a joint property to include it in a will. There are, however, provisions that can be made to assist you, in particular where properties are held as joint tenants, to assist you in making a will. And this is called what is known as a mutual will, where each party who are joint tenants to the property will make their will and indicate that in the event of my death before this person, then this is what happens. So bear that in mind. When you are making a will, you cannot will anything that is owned jointly between parties. Upon the death of one joint tenant, as I explained earlier, in the case of a married couple who are separated, the survivor takes the property solely. For example, the challenging times that we are living in, we are aware of the separation, which sometimes may lead to divorce. But in between separation and divorce, there may come death. So my husband and I are joint owners of the property. He moves out of the house. He no longer contributes to the mortgage. I am the person living there with the children. I am the person making the mortgage. I have added 2 bedrooms and a bathroom, and I have done quite a bit of expansion and extension. but we did not take any steps to ensure that any legal steps, and this is what is called severing the joint tenant, the joint tenancy. That is not something that I'm going to discuss for this evening because I don't want you to have a overload, but just to bring to your attention what happens. So I die. My estranged husband who left the home over 10 years ago was not contributing to the maintenance of the house. In terms of mortgage, I have done significant expansion, and he now steps in and in some instances will put the children out and take charge of the property because the property is jointly held. So irrespective of us saying that he didn't do anything and therefore it is not his house, because look, from when he moved out of the house, he's not paying the mortgage. So no, there is more that we need to do legally to ensure that we put ourselves in a position that we can make a will where this particular property is concerned. If it is that you do alteration to the will, the testator and the witnesses, the same two witnesses that witness the will, must sign in the margin of the will opposite or near to any correction, crossing out, or any changes which are made. So if it is that you were spelling, you were writing the beneficiary name and you in error said TAM rather than TOM, and in reading over the will, you recognize that error. It is not sufficient to just cross out TAM and insert TOM without you initialing and the two witnesses initialing in that area close as possible so that it can be recognized that that is the correction that you are witnessing. Similarly, for example, for those of us who operate, let us say a checking account, we draw a check, we make an error, we can't just cross it out and still, because the bank will not honor it. We need to initial. But this one now, it's not just who signs on the check, but the witnesses must also initial. There are instances when we are unhappy. You write your will, and this evening I come home and my daughter didn't spread her bed, and I feel so upset with her. You just said, I'm going to change the will. I'm going to take her out of the will. So you take up the will in anger and you strike out the name of your daughter and you go no further. So what happens there? That gift that you were giving to your daughter, you struck her name out of the will, you did go no further, you didn't insert another name, another beneficiary, then that gift will fail. A careless error could mean the difference between a valid will and an invalid will, and an effective gift and an effective gift. So we need to be careful, because at times, yes, we are saying, yes, we have a will, and you have made all the provisions that you need to make. And unfortunately, upon death, and that will is taken up, then it is so fraught with errors that it becomes an invalid will and throws your estate into intestacy. And therefore, again, you are not able to speak from the grave, and the government of Jamaica will make their decision as to who gets what. If you have minor children that are children under 18, it is recommended that in making your will, you name guardians and or trustee to look after their welfare. If you fail to do that, it may result in the court appointing a guardian or a trustee, because the minute you have minor children, you need to make, in terms of additional preparation or arrangement for them, because they do not have the capacity to act for themselves. That is how it is seen by law. They do not have the capacity, so therefore you must do that further step by naming a guardian and or a trustee. You can also have a child or children over 18 years old, but at the time of making the will, you said, this child seems to be a little free-handed with money. The child is 21, but the child is not acting like a child of 21. And therefore, in making your will, you can also dictate or indicate that you can name a trustee to manage the gift until a child is over the stipulated age. So for example, you make the will and you said, to my daughter, Joy Newsome, I give and bequeath the cash in my bank account numbered 001 held at NCB Crossroads, my savings account. And you know that this account has a substantial amount of cash, and it is really intended for Joy Newsome, and it is you're not troubling it because you're putting this away for college education or something of value that you would like the child to get. So you can say, this gift is not to, you name the guardian or the trustee, more so a trustee, to manage that account. And you can go further and stipulate that until this child reach 25, because you're hoping that by then the child would now have matured and recognize the challenging time that we are living in, and know that they cannot afford to squander what was left for me. You can specify that a specific amount is given to the child on a monthly basis to cover maybe their lunch money, school fees, that sort of thing. So whatever way you want to do it, you can say every 3 months, $10, every month, $5. So you can go further into the preparation of your will to ensure that you make provisions for your minor child and even the child over 18 who you do not think has, based on demonstration, is not matured enough to manage their affairs. Choosing an executor. An executor is the person responsible for administering your estate. That is, paying your debts and distributing your assets in accordance with your will. The executor, when you are considering, in preparing your will and you're considering now to name executors, then one of a big consideration you must give, is this someone I can trust? The executor must have the ability to manage your estate. I don't know, for some of us who are on the I'm going to say on the older side of maybe 50 and over, some persons, and in particularly if you're, say, for example, from the rural area and you're going home or you're passing through a particular community, from time to time you will hear persons say, you see that piece of land over there, sir? Master, leave it for him daughter, you know. But she not get it. And why? Because the executor did not complete the job that he was assigned to do, and the property is in dealing with the estate, the executor will put the as is required. The property first is transferred to the executor, and then thereafter the executor is to transfer it to the respective beneficiaries. But some executors go no further than transferring it to themselves. So it is important that in choosing your executor, it must be someone you can trust. And you should, I recommend strongly, get their consent that they are willing to act. Because some of us, in terms of the estate that we may have, it requires time and effort, and persons will say, but she did not ask me. And this comes at a surprise, and I don't want to take this job on. And it is also for that very reason why it is recommended that you name 2 executors. Consideration in terms of the age of the executor. So I am 40 years old. It is wise not, yes, you may trust this individual, but it would be wise not to name somebody who is in their late 70s going on 80s as the executor, for obvious reasons. They are not capable, they may very well die before you do, and then you forget now to make some amendment or change in terms of to update the will in terms of assigning new executors. I had earlier mentioned about the residuary clause, and this is a very critical element of the will. So if it is that you go into the bookstore and you purchase a will form, the will form already has that clause typed into it. However, if it is that you are typing your will, preparing it by computer, then it is critical that a residuary clause is included in the will. A will operates upon your death, and therefore it affects property acquired by you after the will is signed. So I made my will 2 years ago, and in 2021, even in the challenging time, I have acquired a house. So that house would not be listed in the will, and neither would it would not be named in the will. So no beneficiary is named, nothing at all. There is no mention of that property. So the residuary clause is classified as a catch-all clause. It is usually the last paragraph, and it commences with the words all the rest and residue of my estate, and speaks to the rest of the estate not specifically distributed. What is critical though, in the, say for example, in making your will in 2021, and you, in preparing your will, you had forgotten, oh, I forgot that I had this bank account. I remember, no, it's not a joint account, but an account which is solely in your name, or this piece of land that I had purchased oh so long ago. So you had forgotten about them. So they were not specifically named in the will. The residue, in doing your residuary clause, what is important, even though these items are not named in the will, when you do the residuary clause and you say, all the rest and residue of my estate, I give to my 2 daughters to be shared equally. All the rest and residue of my estate, I give to my siblings to be shared equally. All the rest and residue of my estate, I give to my dear friend Martha to take solely. So anything at all that is not named in the will, the residuary clause will take care of that. So therefore, even in writing the residuary clause as to who it is you want to name in the residuary clause, due consideration must be given. So you have to be very thoughtful to say, in the event I omitted something, who would I want to leave this to? And you can just like the will, you can, the main part of the will or the body of the will, and you say, my house at 10 Chancery Lane, I leave to my daughters to be shared 50-50. A similar consideration must be given when you are preparing the residuary clause. So here is another thing. I'm getting married. Marriage revokes a will made prior to marriage. Let me say that again. Marriage revokes a will made prior to marriage. So if it is that you prepared your will in 2018 and you got married in 2021, that will was revoked by marriage, unless the will was made in contemplation of the marriage. So it is crucial that you prepare and execute a new will after marriage, even if your wishes remain the same. So I prepared my will in 2018, got married in 2021. I do not wish to change anything at all that I'm distributing in my will. I don't want to change the beneficiaries I have named, nothing at all. Simply, if you got married on the 9th of May 2021, you can redo that will on the 10th of May, as it comes after the date, because the one up to the 9th of May is revoked because of marriage. So you are free to change your will at any time, but you must ensure that the new will is properly executed and the old one is destroyed. I know as human beings, sometimes we like to hoard. So you redo your will, but you still hold on to the old one. Don't do it. You are running the risk of some serious problems. So the minute you make a new will, you need to destroy the old one. So if you make a will and there are other provisions, for example, what is called a codicil. So it is really not redoing the entire will, but basically you have now acquired something new and you want to put that in the will. You don't want to rewrite the entire will. You do that codicil, same provisions are required, sign in the presence of the witnesses, and you affix it to the first will because it will be a part of that first will. But if it is, you have decided that I am going to redo my will in its entirety, do not hold on to the old one, destroy it, because that can become a very contentious issue, especially if my first will named my children as the beneficiary to my home, and my second will, well, you can only have one will, and the later will names somebody else, and these two documents are found, and that is where the contention begins, and people start to twist up like the corkscrew. So at times we leave things to our children, and persons looking on, because we make our will, we have done the right thing, we have prepared our will, we have named our children as the beneficiary, whomsoever we wish to name as our beneficiary. And yes, and our neighbors know how hard Mrs. Newsome and Mr. Newsome worked, and they build this place brick by brick, block by block, and look what the children have done. They are wanting to sell the property. How could they? Yes, so you have left the assets for the children and loved ones. And with that, they will be in a better position than you were. That's your thinking. The question though is, are they able to afford the payment of the cost of the probate? Because the will has to be probated in the court, and that comes at a cost. The payment of the estate duty, so while the probate is taking place, and the documents now go to the stamp office, and the stamp commissioner says, based on the value of this estate, estate duty is owing in the amount of $3 million. And that child or the children do not know where the first cent is coming from. So yes, the property was willed to them, but they can't afford to pay the cost of the probate, the estate duty, and all the attendant cost that goes with that. So they, in doing the probate, they may enter into an arrangement with somebody to say, listen, I have this property, can't afford to pay the estate duty and taxes, and we are prepared to sell. And they enter into a legal arrangement and dispose of the property. And yes, ultimately, they will, in terms of a cash value, they will get that. But I am sure for most of us, our intention was for children to hold on to that particular property that we left to them. Bear in mind, taxes must be paid within 1 year after death. Otherwise, the estate will attract an interest of 6% per annum until it is paid. And when I say taxes, I'm making reference to the estate duties and other taxes. Because even in death, your estate will attract estate duty that must be paid. And if they hold on to the estate and do not wind up the estate and distribute the property, then it will attract an interest of 6% per annum until it is paid. So how can we assist with that process? So we have willed the property to them, but we still have to go a little bit further and say how best, or consider how best to can I assist. So this is where an insurance policy comes in. So you purchase the insurance policy, you so the children could be named as the beneficiary, with the understanding that the proceeds from the insurance policy will now be used to pay the estate duty, the probate fees, etc., etc. So this is one way that you can further assist in the process. And these at times can be relatively inexpensive and can result in significant benefit to your loved one. So in this regard, you can also speak now with your insurance agent to get advice where that is concerned. Proceeds can be used to pay, will be paid directly to the named beneficiary, which they can use to pay the relevant estate duty and taxes, as I said previously. Remember, if you leave no will, then it's not your will that will be done. I thank you, ladies and gentlemen who are listening, and please remember the information provided is a guideline to aid in making your will, but in order to ensure that you get it right, it is advisable that you consult an attorney so that they can guide you in the process. I thank you so very much for listening. I don't know, I leave that to Sister Darlene. If persons have questions, I am open to take questions and see how best I can assist.
Wow, thank you so much, Sister Newsome. That was very comprehensive information for all of us. And I'm sure that there are some questions. If you have a question, I ask that you raise your hand and be recognized.
There are some typed in the chat.
Right, I noticed some things in the chat. Sister P says, Sister Charmaine, just confirming that if you are appointing a child to manage things through a power of attorney, it should be someone who is over 18.
Yes, that is correct, because for the very same reason, we say that the child, the person must have the capacity in terms of witnessing a will. The same age is applicable if you're appointing someone to act as an attorney for your minor child.
Okay, great. So they should be 18. Will the presentation be shared by email?
Sure, not a problem at all.
Okay, great. So Sister Emily, the presentation will be shared with everyone. And Sister P is also asking, was that changed by a legislation Okay, beneficiary witnessing the signing of the will. Was it changed by legislation or case law?
It was changed by legislation, the administrators general, forgive me, but it was changed by legislation. A wide rafting number of changes were made the 2000s to include the beneficiary witnessing a will, and the gift would not fail.
Okay. Great, thank you. And the other, I agree that if you wish to include property owned as a joint tenant in your will, one can say in the event that the other dies before me, just in case you don't get to make a will after. Okay, yes. She's just confirming that she agrees with that.
Okay.
Unfortunately, some executors might only be interested in the commission.
Indeed, and that is why I say that when you're considering naming your executors, get their consent. Also, make sure it is someone you trust, because you find more often than not, the executors are not interested in the 6% commission. But I am also aware that persons are, that is the motivating factor, the 6%.
Okay. How many copies of the will should you prepare, especially if you have two executors and would like each to have a copy in the event of the death of one?
You are going to have a copy, one will. You let your family member, whoever you want to know, whether it be the executor, your beneficiary, or your friend, that listen, my will, if in the event something should happen to me, my will can be found in my top right-hand chest drawer. My will can be found in the shoes box on top of the clothes closet, that red shoes box. My will is for some persons who have a safety deposit box. Then you say to them, it's at the bank. You only have one, one.
Yes, one. Sister Maxine, it's your turn. You can unmute and ask your question.
Thank you, Sister Darlene. Sister Charmaine, thank you so much.
You're most welcome.
Every time I hear it, seems like you add on something else. the two things, that point that you made about the taxes, the payment of the taxes and the affordability is, thank you so much for that. Stress in life and stress in death, right?
Yes.
Much appreciated. What the other thing is, could you please speak to the difference? Because I know of instances where it caused problems because people don't understand the difference between joint tenants and tenants in common.
All right.
Often enough.
Joint tenant. So I am acquiring my house. My husband and I are acquiring my house. Acquiring a house. And one of the critical questions to be asked is, how do you wish to acquire this property? Is it joint tenants or tenancy in common? Tenancy in common, it means that I can say I have a share. It does not have to be in equal share. It can be 50-50, 70-30, 60-40. So it is that it is very specific. And if it is a house you're acquiring, the title will say that. The property is held as tenancy in common in equal shares. The property is held in as tenancy in common 70% to X and 30% to Y. So it is very specific in terms of share. Any document that the title will tell you. If it is that, so in holding any property as tenancy in common, I can now make a will and say, my 30% share held in my house at 10 Chancery Street, I give to my daughter. Your husband can say is 70% share in the property at 10 Chancery Street, I give to my brother. I mean, later on now you're going to have the issue of the brother and the child owning the property, but that is another thing. But that is what happens. However, when you talk about joint tenancy, no one has any divisible share. So you can't make a will and say, I give and bequeath my 50% share in the property at 10 Chancery Street to my daughter, because you do not have a divisible share to will. So, and that is what the term now, the right of survivorship, prevails. So if it is, I own this 10 Chancery Street as joint tenant with my husband, and my husband should pass tomorrow, God forbid, then after your grieving process and everything, you now make the necessary arrangements, and what is done is that you note the death. You can't take off your husband's name off the title. What they do is note the death of your husband, and that property belongs to you and you alone. Nobody, save and except the bank, can come and speak to you about the property. No family member can say, he told me that if anything should happen to him, I can come here to live, and him giving me his share. There is no share to give. And hence the reason for my comment about the making of a mutual will, so that my husband and I own property jointly. He makes a will, I make a will, and both of us will, for want of a better term, mirror each other, because he's saying that in the event of my death, if I should die before my spouse, then this is what should happen, and vice versa. I say the same thing. I mean, you have situations, and I don't want to get too complex, that in the event something should happen, let us say parties separate, the property is owned jointly, you can either say, all right, sell the property and let us share the money equally, or you come to an arrangement, or you can also go to the court to ask the court to sever the joint tenancy. But it is not by word of mouth that you can say my share and his share. It has to be done. Steps have to be taken legally in order to speak about my share and your share. I don't know if that is clear.
For me, it is.
Okay, great. It's clear for Sister Maxine. Hope it's clear for everybody
For everyone,
else.
yes.
Yes. Any other questions?
I see a question which says, if one of the executor cannot be located.
Yes, you had answered that one.
Oh, okay.
Yes. You had answered that one. Any other question? I have a question. Can a beneficiary be an executor?
Yes. No, there is no problem, no issue with that at all. The beneficiary, because sometimes we do our will, and you can say we can keep it in the family. So I need my daughter is the beneficiary and she's the executor. So it's up to her. Let her sort this estate out.
Okay.
Yes.
Okay. Great. There's a question from Brother Cleve. If one party to a mutual will passes, is the other party obliged to honor the terms of the mutual will?
But remember, in terms of the terms of the mutual will, it is not that you are saying, yes. Let me just say yes, because it is your will, and the person's, and it is in the event of death. This is what you want to happen. So yes. I mean, you can contest it, but one would have hoped that when the parties, the joint owners, are making that mutual will, there is some discussion and agreement as to exactly how we want to deal with that estate.
Right. Please give an idea of the cost that will be incurred to probate a will payable to the government and to an attorney who prepares and files the probate. Some persons may think that after they die, everything in the will becomes effective automatically, not realizing that this process you have to go through this process.
All right. So and that is a step further in terms of probating a will. So you have named 2 executors. You have made your will is valid, and you are now talking about the probate. What is required is that an application for a grant of probate is done in the Supreme Court. And it is now, all right, so in terms of the cost, attorneys would normally charge, I think, anywhere between 3 and 5% of the value of the estate in terms of preparing the application and taking the process through completion and to distribution. However, outside of the cost, the attorney's fee, the professional fees, let me make that distinction, the professional fees, that is a fee that the attorney will charge, then the persons are now required to pay the estate duty and the various applicable fees, the stamping of the probate, that sort of thing. So it is for that reason I made the suggestion or the recommendation that to assist with these costs, one could buy insurance to deal specifically with the understanding that the beneficiary who is named on that policy knows that this is the reason why this was done. And yes, it is true that the minute, for some persons, the minute my father dies, tomorrow I can come and I take charge, and sometimes they're not even named in the will, you know. They take charge and they say, Daddy did tell me that this van is mine. I lock in the house door. I don't want nobody coming here, nobody not coming in here, that sort of thing. No, the correct thing is that the will must be probated and distributed before anyone takes charge. And it goes right back again to the issue that I made. The executor that you name must be capable and somebody that you can trust. Because remember, the purpose of the executor is to manage the estate. So the minute the executor, the will is read, and yet these persons know that they are the executor, they have a duty to collect for want of a better, to now seek to identify the properties held in the estate and to take charge. So, for example, I have a property that is rented and I die. One of the duty of the executor, it is the executor who is supposed to be collecting the rent and put it in a bank account, that when the will is probated and the distribution takes place, it forms that collection of the rent over the 2 years or longer period, forms a part of the estate for distribution. It is not supposed to be a child coming in and taking charge, even if ultimately the child is the beneficiary.
Okay, thanks for that. Sister Maxine has another question. You may ask your
just following up on Brother Cleve's question. Wouldn't in the situation of a mutual will, wouldn't upon the death of the first person,
yes,
wouldn't that become redundant?
The mutual will?
Meaning the will for the first person who dies, wouldn't that become redundant?
If that will of the person
mirror each other, if they mirror each other,
yes,
assuming they're identical,
right?
Wouldn't that one become redundant upon the death of the first person?
No, it would not become redundant, because what happens is that it now provides, I'm going to say, a position that the survivor can now move on to do certain things in terms of the preparation, or now putting in place the arrangements in terms of the entire estate, the entire estate. Because remember, Sister Maxine, for example, if it is, I am saying we have a mutual will, and I say, in the event of my death, I would want my daughter to benefit from my estate. And I say the same thing. So right away, we know exactly what is to happen. And I must confess, it is not something that I practice, and it is for this reason I would say that legal advice is critical in the preparation of a mutual will.
Okay.
What I can do, because I recognize that quite a few of us in acquiring property, it is done jointly. I thought it important to raise that issue. But what I can do is to speak to the person with much more authority, and I can provide an update where that is concerned.
Okay, thank you.
All right, thanks. I recognize too that we are beyond 9, but I'm sure you agree that this is very important. We have a couple other questions. If you will give us a few more minutes to go through.
Not a problem at all. Not a problem.
Okay. Brother Cornell is saying, real situation. My father died, mother still living. One executor is dead, the other is blind. How do we go forward?
All right, let me read it. My father died, mother is still living. One executor is dead and the other is blind. All right, so your father died, left a will. I'm going to take it. And so, all right, so we can, I'm going to say we can, for the purposes of responding to the question, I am going to drop mother from the equation because it is father died, leaving a will. He has he named two executor, the other is blind. So the executor that is blind can still act. Because remember now, I had said earlier that being blind, illiterate, does not prevent you from making your will. So you mark the X. So let us say the executor who is blind, no, because she's not the witness, she's the executor. So the person who is now preparing the probate, there would now need to be a clause which would say why the person is unable to sign. So there is no issue. One, reference would have to be made that the executor, one executor is deceased and provide proof that the person is deceased. And then the other who is blind, the person preparing the application for the grant of probate, the person will mark their X, and then the attestation clause will say as to what is the reason why the person marked an X rather than doing a signature. So there is nothing to prevent you from going forward at all. Your challenge would be a little bit more if both persons were dead, but you can, there's nothing to prevent you from going forward.
Okay. Brother Cornell, I hope you're satisfied with that response. In addition, Sister P gave you some additional advice. Visit Sister Charmaine's legal chambers tomorrow with all the documents in hand. She's also saying, if you go that route of the will, leave some liquid cash, and reinforcing what you said, maybe even a few million, depending on the value of your estate, house and land, bank deposit and insurance policy to cover costs.
Indeed. Indeed, because what we don't want is we work so hard, leave these assets for our loved ones, and then it falls into ruins. They have to dispose of it, they can't manage. So we want to ensure that we put everything as best as possible in place so that they can survive.
Yes, I totally agree. And we know of situations in Jamaica, quite a bit of persons after their loved ones have died, family, brothers, sisters who had very good relationships, and after the will, you know, after their parent or sibling, whoever has died, then they are into issues because a proper will wasn't done. And they're trying now to figure out who should get what and you know, all of that. So it's very, very important. Thank you so much, Sister Newsome. This was really, really great information for all of us. I'm sure we benefited significantly. And we're going to be thinking now, based on the wills that we've already made and the ones we have not yet made, how it is that we should go through the process. Thank
Indeed.
you so very much.
You're most welcome. It was my pleasure, and I'm happy to serve.
Great.
And remember, final word, if you do not make your will, one will be made for you.
Indeed, if you do not make your will, one will be made for you. So if you have not made your will, tomorrow is the next day. Remember, tomorrow is promised to no man either. So
Yep.
make it now, maybe tonight. If you can find two witnesses somewhere, I guess.
They can make it tonight and find the witnesses tomorrow.
Tomorrow, right.
Just make it, but don't sign it.
But make it and don't sign it. Right. Appreciate it. Thank you so much. We went a little over time, but I'm sure you agree that it was really worth the while.